This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. So Google v. Oracle is finally over. The Supreme Court granted certiorari in, I guess, 2020 or so, and finally released an opinion on April 5th, Monday a week ago. And it is saying that Google made a copyright fair use, a permissible fair use of Oracle's Java SE platform when it copied, I think, 37 interfaces and 11,500 lines of code of the Java SE program. It's a programming language, and if Google had copied the entire thing and implemented it into Android by copying the whole thing, that probably would have been copyright infringement, although we don't have that answer. But they didn't copy the whole thing. They copied 0.4% of it. They copied only the interface language, and then they wrote their own code behind those interfacing functions. So this is a very long opinion that I'm going to summarize here by reading only the syllabus and then talking about it a little bit. Let's go over what the court has to say in 2 or 3 pages, and then I will give you some more context. And then later this week, I will release a full reading of it, kind of like an audiobook, if you want to hear Justice Breyer's entire opinion. Oracle America owns a copyright in Java SE, a programming platform that uses the popular Java computer programming language. In 2005, Google acquired Android and sought to build a new software platform for mobile devices to allow the millions of programmers familiar with Java to work with its new Android platform. Google copied roughly 11,500 lines of code from the Java SE program. The copied lines are part of a tool called an application programming interface. An API allows programmers to call upon pre-written computer tasks for use in their own programs. One of the examples that the court will give later on is adding 2 numbers together. You might call a function that's called add 2 numbers, and then you give it the first number and the second number, and then the function will return the 2 numbers added together. Well, the interface is the name of the function and the format of the parameters, add 2 numbers, number 1, number 2. And then the implementing code or the operating code is the actual programming code that actually adds the 2 numbers and spits back the result. Google did not copy the operation. Google copied the format, the add 2 numbers and then, number 1, number 2. And that's what they're saying is a fair use. Over the course of protracted litigation, the lower courts have considered 1, whether Java SE's owner could copyright the copied lines from the API, and 2, if so, whether Google's copying constituted a permissible fair use of that material, freeing Google from copyright liability. In the proceedings below, the Federal Circuit held that the copied lines are copyrightable. After a jury then found for Google on fair use, the Federal Circuit Court of Appeals reversed, concluding that Google's copying was not a fair use as a matter of law, overriding the jury. Prior to remand for a trial on damages, the court agreed to review the Federal Circuit's determinations as to both copyrightable and fair use. The court meaning the Supreme Court. Held Google's copying of the API, which included only those lines of code that were necessary to allow programmers to put their accrued talents to work in a new and transformative program, was a fair use of that material as a matter of law. A. Copyrights and patents, the Constitution says, serve to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. From the Constitution, Article 1, Section 8, Clause 8. Copyright encourages the production of works that others might cheaply reproduce by granting the author an exclusive right to produce the work for a period of time. Because such exclusivity may trigger negative consequences, Congress and the courts have limited the scope of copyright protection to ensure that a copyright holder's monopoly does not harm the public interest. This case implicates 2 of the limits in the current Copyright Act. First, the Act provides that copyright protection cannot extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery in Section 102B. Second, the Act provides that a copyright holder may not prevent another person from making a fair use of a copyrighted work, Section 107. Google's petition asks the court to apply both provisions to the copying at issue here. To decide no more than is necessary to resolve this case, the court assumes, for argument's sake, that the copied lines can be copyrighted and focuses on whether Google's use of those lines was a fair use. The doctrine of fair use is flexible and takes account of changes in technology. Computer programs differ to some extent from many other copyrightable works because computer programs always serve a functional purpose. Because of these differences, fair use has an important role to play for computer programs by providing a context-based check that keeps the copyright monopoly afforded to computer programs within its lawful bounds. The fair use question is a mixed question of fact and law. Reviewing courts should appropriately defer to the jury's findings of underlying facts, but the ultimate question, whether those facts amount to a fair use, is a legal question for judges to decide brand new. This approach does not violate the Seventh Amendment's prohibition on courts re-examining facts tried by a jury, because the ultimate question here is one of law, not fact. The right of trial by jury does not include the right to have a jury resolve a fair use defense. To determine whether Google's limited copying of the API here constitutes fair use, the court examines the 4 guiding factors set forth in the Copyright Act's fair use provision: the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, and the effect of the use upon the potential market for or value of the copyrighted work. The court has recognized that some factors may prove more important in some contexts than others. 1. The nature of the work at issue favors fair use. The copied lines of code are part of a user interface that provides a way for programmers to access pre-written computer code through the use of simple commands. As a result, this code is different from many other types of code, such as the code that actually instructs the computer to execute a task. As part of an interface, the copied lines are inherently bound together with uncopyrightable ideas, the overall organization of the API, and the creation of new creative expression, the code independently written by Google. Unlike many other computer programs, the value of the copied lines is in significant part derived from the investment of users, here computer programmers, who have learned the API's system. Given these differences, application of fair use here is unlikely to undermine the general copyright protection that Congress provided for computer programs. 2. The inquiry into the purpose and character of the use turns in large measure on whether the copying at issue was transformative, i.e. whether it adds something new, with a further purpose or different character. Google's limited copying of the API is a transformative use. Google copied only what was needed to allow programmers to work in a different computing environment without discarding a portion of a familiar programming language. Google's purpose was to create a different task-related system for a different computing environment, smartphones, and to create a platform, Android, that would help achieve and popularize that objective. The record demonstrates numerous ways in which re-implementing an interface can further the development of computer programs. Google's purpose was therefore consistent with that creative process that is the basic constitutional objective of copyright itself. Google copied approximately 11,500 lines of declaring code from the API, which amounts to virtually all the declaring code needed to call up hundreds of different tasks. Those lines, 11,500, however, are only 0.4% of the entire API at issue, which consists of 2.86 million total lines. In considering the amount and substantiality of the portion used in this case, the 11,500 lines of code should be viewed as one small part of the considerably greater whole. As part of an interface, the copied lines of code are inextricably bound to other lines of code that are accessed by programmers. Google copied these lines not because of their creativity or beauty, but because they would allow programmers to bring their skills to a new smartphone computing environment. The substantiality factor will generally weigh in favor of fair use, whereas here, the amount of copying was tethered to a valid and transformative purpose. 4. The fourth statutory factor focuses upon the effect of the copying in the market for or value of the copyrighted work. Here the record showed that Google's new smartphone platform is not a market substitute for Java SE. The record also showed that Java SE's copyright holder would benefit from the re-implementation of its interface into a different market. Finally, enforcing the copyright on these facts risks causing creativity-related harms to the public. When taken together, these considerations demonstrate that the fourth factor, market effects, also weighs in favor of fair use. The fact that computer programs are primarily functional makes it difficult to apply traditional copyright concepts in that technological world. Applying the principles of the court's precedents and Congress's codification of the fair use doctrine to the distinct copyrighted work here, the court concludes that Google's copying of the API to re-implement a user interface, taking only what was needed to allow users to put their accrued talents to work in a new and transformative program, constituted a fair use of that material as a matter of law. In reaching this result, the court does not overturn or modify its earlier cases involving fair use. And this is a 6-2 decision with Judge Barrett abstaining. So it's Breyer, Sotomayor, Kagan, Gorsuch, and Kavanaugh against Alito and Thomas, with Justice Barrett abstaining, which is probably because she came into the whole discussion a little bit late. So that's very interesting, and the programming world has breathed a collective sigh of relief, as one of our viewers said, because what would be the implications of this would mean that the implementing code, the function names and formats of parameters would need to be different for every single programming language. And so you could, the first person to create add two numbers, X and Y, would have a copyright on that function, and nobody else could add two numbers by making a function called add two numbers. You'd have to create a function that was like add numbers together, but only two. The names would have to be different. The formats would probably have to be different. It would have to be sufficiently different not to implicate copyright protection. And it was one of the dumbest rulings that I had ever heard of when an appeals court ruled in favor of Oracle. It seemed like maybe they didn't understand how programming worked and hadn't made the distinction between copying the code, which makes two numbers add together, versus copying the code which calls the function that adds two numbers together. So it would be different if a function was a line of prose, like when you go to see a recipe, like from a Recipeasly case, when you go to view a recipe and you've got like the life story of the programmer. If they copied the life story of the programmer, that would be copyright infringement. But they didn't. They copied the implementing codes so that you could learn Java and then go to Android and use the same add two numbers function and then get a similar result, the same result, without Google actually copying how the computer adds two numbers together. So that's the correct result. And there's another 58 pages of court opinion to go. So I will probably read through that later this week so that everyone can have sort of a historical audiobook format of what that was like, and we'll discuss it further. But let me know what you think in the comments below. So that's our show. Thanks for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education program, here on YouTube, also on Floatplane, and on twitch.tv at Sunday mornings at 10 a.m. Eastern Time. This is a community-supported legal education channel, meaning we need your financial support on a monthly basis on patreon.com/ljfrench, on sponsors.com/law, or through YouTube membership or Floatplane membership. Thank you very much in April of 2021 to our $50 plus supporters: Joe Tyson, John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Rudolph Bescherer Jr., Torpedan, Brandyn Abel, Sovereign Tittizen, ShadowTycho, RDHDragon, and Earthbound Star. And thank you very much to the $5 plus supporters. Everyone's been scrolling on the updated LED panel behind me and will be on the videos in front of me that drop. I love you all. Have a great week. I hope you all had a nice holiday weekend, and I will see you in the videos. Bye.
Your mum sounded better when she done the gobble gobble.